Okay. All right. So Amanda Tuminelli will be joining us on the screen, hopefully, um, momentarily. There she is. Okay. So back in January, the first PGP of this year, we discussed how, despite the friendlier posture by the new administration toward the crypto industry, there weren't any indications at that point that it intended to change course, at least radically, when it came to the previous administration's prosecution of software developers of crypto privacy tools, specifically the Ethereum based privacy tool Tornado Cash and the Bitcoin based privacy tool Samourai Wallet. And now, 5 months into the Trump administration, in many ways, it's still the case that the administration hasn't changed course. But on the other hand, there have been kind of a lot of things that have happened since we last spoke on this topic. So we're privileged to have two of the foremost experts on these subjects join us this morning. On the screen, we have joining us from New York is Amanda Tuminelli, the Executive Director, Chief Legal Officer of the DeFi Education Fund. Joining me on stage is Peter Van Valkenburgh, Executive Director at CoinJoin. So let's get started. Speaking of Tornado Cash, Amanda and Peter recently published a brief focused on Tornado Cash developer Alexey Pertsev's case in the Netherlands. So let's start there. Amanda, can you please explain what the Pertsev brief is, who it's for, and what the goal is of the brief?
Sure, happy to. Can you hear me okay?
Yes.
Okay, great. So Pertsev in the Netherlands was charged with money laundering and was already convicted at the lower court level of money laundering. And we're now working on his appeal. And what's different in the Netherlands versus in the United States is in the Netherlands, you're actually allowed to relitigate all of the facts on appeal. In the United States, right, you're limited to the record below. You can't add new facts, you can't add new expertise. And so what we decided to do, Coin Center and DEF together, was put in an expert report to provide some additional fact analysis and opinions on how DeFi works, how privacy preserving protocols work, and why simply publishing code is not illegal, and why when third parties use your code for whatever it is they're using it for, you should not be held responsible for that as a software developer. So that's high level what the brief is about, and we're hoping that it will be meaningful to the appellate court in the Netherlands.
And that is that specifically aimed at misunderstandings that you guys observed the first time around, or is it just does it just generally seem like the judge didn't understand how the tool worked?
I'm interested to hear what Peter has to say about this too. I think that it's that the court was not as sophisticated on the technology at issue and really didn't understand the nature of immutable smart contract protocols. I think that the court made the assumption, which unfortunately courts here do too as well, which is that like the developer can do something about a third party using their code for bad conduct, when in fact, as we know with the immutable smart contract protocol in Tornado Cash, the developers could not do anything when third parties were using it to launder money. So I think the court made that mistaken assumption and probably made some other bad assumptions when it comes to the tech.
Yeah, I mean, for a little bit of extra context, because it's important, it's actually quite radical what Alexei was charged with in the Netherlands. He was charged with the primary offense of money laundering. So in the US, Storm and Semenov have been charged with conspiracy to launder money, which the government has to prove then that you had an agreement with co-conspirators, known or unknown, to further some criminal act. Now, I think that that's actually a weak case here in the U.S., here in the Southern District of New York, and I think Roman Storm is not guilty of that charge as well. But in the Netherlands, he's not even being charged, Alexei's not even being charged with conspiracy or aiding or abetting. He's being charged with actually laundering money. And that criminal charge carries a maximum 8-year sentence, and the judge gave him 5 years, which is still higher than the mean, and cited the sheer amount of money that Alexei laundered, which is if you take certain statistics, which are of dubious value, but if you take certain statistics, is in the high millions to billions of dollars range as far as amount of money that went through Tornado Cash. So there's an obvious misunderstanding here. because there's simply no world where Alexey even handled billions of dollars. He built a tool that others used to handle their own money, and collaboratively or individually, all of that amounts to many millions, if not billions of dollars. But Alexey certainly did not handle that money. And so the idea that you'd charge someone actually with money laundering because you created open source software that others used to move billions of dollars, some of them for legitimate purposes, some of them possibly for illegitimate purposes, probably. It's outlandish and extreme, and I think it signals that there was a miscarriage of justice, probably because of a lack of understanding of what Alexey had actually engaged in, the act of publishing software and maintaining a website versus the act of operating a truly trusted and custodial financial institution. If you operate a financial institution, i.e. you hold people's money and you launder billions of dollars for criminals, then that sentencing guideline kind of makes sense. But this is not like that case at all. And the potential legal risk that this creates for anyone else in the world who wants to publish software that could be misused to do bad things is significant. I think the chilling effect, especially in the Netherlands, let alone the EU, let alone globally, is substantial. And so we really want to make sure that at the appellate level, where we're fortunate they can reinvestigate the facts, they get those facts right, and they hopefully rethink that charge.
Right. Okay, so I'm going to introduce another character. I mentioned this at the beginning of this panel, but on the money laundering charge, so Peter mentioned Storm and Semenov. That's a reference to Roman Semenov and Roman Storm. Roman Semenov is not in the U.S. I'm not sure exactly where he is, but Roman Storm is facing trial scheduled for July. Is that correct?
Last I heard, yes.
July. And then there's a Bitcoin project, the Samourai wallet, and the developers Keon Rodriguez and William Lonergan Hill also face a money laundering charge in the U.S. Samourai wallet works differently than Tornado Cash, but I was wondering, Peter, if you could explain how even though the underlying technical design is different, the legal arguments are the same or similar as the ones in the Tornado Cash cases, both in the context of the money laundering charge as well as a second charge, which we'll start talking about, which is the unlicensed money transmission charge.
Yeah, so both Storm and Semenov for Tornado Cash are charged with those two charges. They're also charged with the sanctions, conspiracy to violate sanctions charge, which we'll set aside for the second. And Rodriguez and Hill are charged with money laundering, conspiracy again, and unlicensed money transmission. So, the Tornado Cash tool was a smart contract on the Ethereum blockchain and corresponding website, and that website was a user interface. That website and its user interface were in fact open sourced, so you could even run them locally on your own computer. So a lot of this really does boil down to publishing software and hosting that software on infrastructure that you do control. But what you're hosting is software, not people's money, right? Now, Samourai Wallet was a Bitcoin privacy tool. It was a wallet that you would, have custody over your own funds, and the wallet would help you make CoinJoin transactions. CoinJoin transactions are a way of making a transaction in Bitcoin that makes it more difficult for the public ledger or more difficult for people to look at the public ledger of Bitcoin transactions and see your full transaction history. So it's very similar to this Tornado Cash tool, which use zero-knowledge proofs. CoinJoin transactions use different cryptography and different economic incentives to, however, achieve basically the same result. Now, Hill and Rodriguez developed the Samourai Wallet software. Publishing software for Bitcoin wallets is not a regulated activity. It's not something that you should be charged with unlicensed money transmission for doing. That's FinCEN's 2019 guidance said that very clearly, let alone any plain reading of the relevant regulations and statutes. So the fact that they are being charged is, to me, as outrageous as the fact that Storm and Semenov are being charged. Now, there's an additional wrinkle here that I think trips people up, which is that the Samourai Wallet developers operated something called a coordination server. And a coordination server for CoinJoin transactions is basically like Craigslist. It says, hey, we've got some users over here who are holding their own Bitcoin who want to make a confidential transaction. And there's some users over here who want to make a confidential transaction. If they could find each other, they could make one larger transaction, and they would not be entrusting their money to any third party or to each other in the process, but it would be harder to then disambiguate each individual transaction out of that confidential transaction. And so you're operating a server, a coordination server for creating these confidential transactions amongst multiple potential users. You are not holding people's Bitcoin in the process, and you don't have any control over where they send their money when they make those confidential transactions. All you're doing is basically, as I said, something very Craigslist-like, creating a communications platform by which people who want to protect their privacy together can do so. So hopefully this makes it clear why we take issue with both the Samourai prosecution and the Tornado Cash prosecution. In both cases, you had people primarily engaged in software development, secondarily engaged in hosting that software on websites and doing other communications intermediary-like roles, none of them having specific agreements with any specific users to further any specific criminal acts, and none of them having any actual control over any user funds. So without control over user funds, I would say that the unlicensed money transmission charges are inappropriate. See the FinCEN 2019 guidance and reasonable readings of the regulations and statutes. And without any specific agreements to further specific illicit transactions with any specific users, I don't think the money laundering charges or conspiracy to commit money laundering charges stand either. And I treat these cases as very similar. It's just one is in the Bitcoin world with Bitcoin privacy tech, confidential transactions, and one's in the Ethereum world with zero knowledge proof privacy tech, the smart contracts for Tornado Cash.
Mm-hmm. Okay, I want to dig into this a little bit more with Amanda and talk about Section 1960 and talk about how there's this, it contradicts what FinCEN said in 2019. So yeah, Amanda and Peter and others in the crypto policy community have pushed back especially hard on this unlicensed money transmitting charge. And Amanda co-authored a paper on it, which we talked about in January. For the folks that aren't familiar, Amanda, can you help us understand what Section 1960 is? I'm sure that you explain this many, many times a day and per week. How the DOJ has been using it and why, in your view, it's the incorrect use of the statute?
Sure, happy to. And it really has become a daily, a daily occurrence lately. But no, so if you are transferring funds on behalf of customers, you are a money transmitting business. So think Venmo, think PayPal. These are services that exist so that if I want to send money to Peter, I can go to PayPal and they will send my money on my behalf to Peter. They take custody and control over my funds and they send them on their way. Now, Section 1960 makes it a crime if a business like Venmo or PayPal does not get a license to do that. So states issue licenses and the federal government issues licenses for money transmitting businesses. If you don't get one, that is a federal crime under 18 U.S.C. 1960. But what is very clear in the statute itself is that the way that money transmitting businesses are defined is transferring funds. It's literally written in the statute. You have to transfer funds on behalf of the public. Now, I think that's clear. I know Peter thinks that's clear, that transferring funds on behalf of someone means that you have to have their funds in your custody or your possession or your control in order to do that on someone else's behalf. However, the DOJ has recently taken the position in the Tornado Cash case, Samurai Wallet case, and some other cases and some investigations that you do not need to have custody or control over a person's funds in order to transfer them under Section 1960. So I think it's very clear that this is a mistaken interpretation of 1960. If you get into the DOJ's arguments, specifically in the Tornado Cash case and the Storm case, they would have you believe that transferring can be very broad and can be all sorts of activities that you would never think of as transferring funds on behalf of somebody else. And I think for anybody who understands the tech, they understand that a DeFi protocol and a DeFi developer is not a money transmitter or a money transmitting business, and we cannot treat new technologies the way we treat centralized entities that actually are money transmitting businesses. So what we really would love to see is a clearer interpretation by DOJ, and possibly if it takes amending the statute, although I don't think you need to amend the statute to interpret it correctly, it would be great if we could make it even clearer in the criminal code that it should not be interpreted the way that the DOJ has interpreted it.
How does 1960 relate to the Bank Secrecy Act? I get tripped up on this. I think it's confusing if you're not a lawyer. This is also kind of a two-part question, because if you can kind of go from that, segue from that into how the way that the DOJ is using this contradicts what FinCEN said in 2019 and explain that, that would be super helpful.
Yeah, happy to. And it is complicated. Like you would think that when the term money transmitting business is used in two separate places in the US code, it would just be interpreted exactly the same way and be consistent because that's probably how it should be done. The DOJ has not taken that position, but the Bank Secrecy Act also regulates money transmitting businesses, defines what they are, and FinCEN has regulations that further interpret the Bank Secrecy Act that give categories of financial institutions that include money transmitting businesses. What's a little bit better in the BSA is that it defines a money transmitting business as one that accepts and transmits funds, so less room for a misinterpretation of how to define a money transmitting business. And then what made it even clearer, and as Peter referred to earlier, in 2019, FinCEN put out guidance that interpreted money transmitting business in the context of wallets, software developers, protocols, and said that if you don't take custody and control over customer funds, if you're simply a developer or software developer of an anonymizing service or anonymizing software and you don't take control, then you are not a money transmitting business. And the industry relied on that guidance in good faith for the past 6 years. The DOJ said in the Storm case that they don't need to listen to the 2019 FinCEN guidance. So they are saying they don't need to listen to the regulator who is in charge of regulating money transmitting businesses because they're going to rely on their interpretation of the statute the way that they've read it. So there is now a big conflict, and you have the Department of Justice telling the public that where there's a conflict in the law, like they're just going to go with their own interpretation and not listen to the primary regulator responsible for this particular conduct.
One more question in this line, and then I'll go back to Peter. But one more from Amanda. In April, President Trump's Deputy Attorney General Todd Blanchard issued a memo that is related to this topic. At a high level, what was Blanchard's message, and specifically, what did it say about 1960? And then I'm going to follow up after you explain it and ask you if it's made any difference or not.
Okay, so the Blanchard memo at a very high level was ending regulation by prosecution. So it was a great title, and it was meant to tell the public that they were going to stop. The DOJ was going to stop regulating people by prosecuting them, meaning they're not going to just announce new policy by putting it in a criminal indictment and instead prosecute crimes that were actually related to fraud and harming people, victim-related crimes, as opposed to simple registration violations. So what the memo said about 1960 specifically was that the DOJ was not going to go after registration cases only. So where the only charge at issue was 1960 B1B, which it alleges a violation of the federal registration requirement for money transmitting businesses. Unfortunately, it did not talk about 1960 B1C, which is the provision at issue in the cases that we're talking about here today. And it sort of left open a question as to how the DOJ would treat those cases. Like I said, I think that the memo had a great title. I think the spirit of the memo was a good one. And there were other parts of the memo unrelated to what we're talking about that I think were positive and were net positives for the industry. I just think for this particular issue, it did not solve anything, as evidenced by the fact that the DOJ dismissed just the 1960 B1B object of the conspiracy, so not even a full charge in this Storm case, and let the 1960 B1C part of the conspiracy charge go forward, which is what Storm will be going to trial on in a month.
Right, so this is really in the legal weeds. I'm going to see if Peter can help pull it out of the legal weeds. So there was an aspect of the money laundering charge that the Southern District of New York decided not to pursue.
The unlicensed money transmission.
Unlicensed money transmission charge that the SDNY decided not to pursue. But how can you still be an unlicensed money transmitter if you don't need to license? It seems a little bit backwards, as we've discussed before.
Yeah, I mean, honestly, it doesn't make sense. So we learned that prosecutors in the Southern District of New York were not going to pursue that B1B charge because Jay Clayton, who's incoming to the SDNY and acting, released a letter, a memo saying that they were not going to pursue that charge. But as you said, there were 2 charges of unlicensed money transmission in that case, B1B and B1C. B1C is knowingly transmitting or transporting criminal funds, but it's still a subcategory of unlicensed money transmission. And so this is all kind of crazy to me, because if you want to charge someone with knowingly facilitating someone's money laundering, then you charge them with conspiracy to launder money, which they have as a separate charge in that case. If you want to charge them with unlicensed money transmission, you have to first prove that they were a money transmitter and they failed to license with someone they were supposed to license with. The B1A part of 18 U.S.C. 1960 says you were supposed to license with a state money transmission regulator, and you didn't. That was never brought. They never brought that charge, maybe because they didn't find, it would be easy to prove that they failed to get a BIT license or failed to get a Wyoming money transmission charter or something like that. The B1B charge is failure to register with FinCEN, the federal money transmission regulator for BSA purposes. And FinCEN says, well, you don't need to register with us. And the Blanchard memo that you mentioned said, we're not going to try and change that policy through prosecuting if the regulator had previously said that that's not their policy. The B1C charge says you're still doing unlicensed money transmission and knowingly transmitting criminal funds. But the question is, how are you still unlicensed? They're basically admitting in their refusal to bring those 2 other charges that they didn't have to register with the states, license with the states. They didn't bring B1A. They're admitting that they didn't have to register with the federal authorities, B1B. So the really difficult question is, if you're going to find them guilty of unlicensed money transmission, but there was no one who was requiring them to license, how insane is that? It's like saying, Mike, you're allowed to drive your scooter, but you have to get licensed. But there's no one in the state of D.C. that licensed scooter driving, so I'm just going to arrest you for being on your scooter, even though you didn't have to get a license. It doesn't make sense.
Right, and it seems like kind of at a high level, there's this argument going on as to whether or not these things are financial institutions, which has been going on for years.
I don't even think there's an argument. They're just not. The regulator that makes that determination, FinCEN, said in 2019, as clear as can be, that you're not, unless you have total independent control of customer funds. But yes, the DOJ seems to think there's an argument.
There are enough people in the government who believe that they should be regulated like financial institutions. Which
even if that's true, then you do it prospectively, not retrospectively. You create new laws that regulate them. I would probably be against them, depending on how they were specified. But you don't say, you've always been regulated. Haha, surprise, now you're going to jail.
By the way, this highly controversial topic is the core of the discussion that we will be having in October for the DC Privacy Summit. So get your discounted tickets. Okay, let's talk about...
If you want to hear me get more irate, yes.
Let's talk about how some of these things might be fixed. And I'm going to start with Peter, then I'll go to Amanda, and I'm going to have the Bank Secrecy Act be your explanation, your opportunity to explain, and then we'll talk about 1960 with Amanda. So yeah, I guess the question is how can these things get ironed out? How can we get more clarity? Does Congress need to amend the Bank Secrecy Act? And if so, how would it do that and when?
Yeah, so one approach is to look at the Bank Secrecy Act, and I agree with what Amanda said earlier, that actually those definitions in the BSA are not that unclear. They're just being certain perceived vagueness within them is being exploited by bad faith prosecution. Like, that's what I think is going on in the SDNY. But to address that, we could be doubly clear by amending the Bank Secrecy Act. Now, amending the Bank Secrecy Act is a lift and difficult, and this is sort of a narrow issue. And so actually, I think the best way forward we have just to give software developers and non-controlling blockchain developers clarity on this issue is actually a law that's already been introduced. It's been introduced since 2018 in the House, the Blockchain Regulatory Certainty Act. The Blockchain Regulatory Certainty Act defines a category of software developer and infrastructure provider who are non-controlling, means they do not have any unilateral ability to move customer funds or user funds. And they don't have the legal right to those user funds either. So it doesn't cover like a Binance. It doesn't cover a wallet developer who retains 2 out of 3 keys and therefore could actually move customer funds. It only covers people who can't control customer funds and therefore aren't money transmitters. And it says if you fit this definition for non-controlling blockchain developer or service provider, you shall not be found liable for engaging in money transmission. You shall not be treated as a money transmitter or similar designation requiring registration under the Bank Secrecy Act. And there's an original text of that law that was reintroduced this year by Representative Richie Torres and Majority Whip Tom Emmer in the House. It's nonpartisan. It should be non-controversial. It's just about providing clarity to people who are developing good tools. And I'm also very excited to share, which some of you might have seen, we talked a little bit in the last interview with Veronica about the Clarity Act. It has been folded into the Clarity Act as a way of, and I hate the title of the Clarity Act for this reason, providing clarity to non-controlling developers that they will not have money transmission licensing liability if they don't control funds. And that Clarity Act text is subtly adjusted. That we got a lot of feedback. The sponsors of the original bill got a lot of feedback. House Financial Services worked carefully to make sure that we would get everyone comfortable with the language such that we were sure it was not going to accidentally open up a giant loophole for actually trusted financial institutions to somehow avoid their BSA obligations and would simply do this narrow and important thing of offering software developers clarity on their legal liabilities. So I think that text in the Clarity Act is excellent. I hope that clarity passes. There's I think other aspects of clarity that are maybe even actually more controversial than this. This one I've heard both from Democrats who are on House Financial Services and Republicans that they're comfortable with this text being in there, and they like the job that it does in offering clarity on money transmission liability.
And Amanda, should Congress do something about the uncertainty around Section 1960? And if so, how and when would you suggest that they do that?
So, as I think Peter and I have both said, I don't think they need to, but I think that they should to close the window for this to ever be misinterpreted again. I think 1960 is clear that it should not apply to non-custodial software developers, but it would be great if it was even clearer, and that the statute itself said that if you do not have custody or control over customer funds, then you are not transmitting funds on behalf of the public. And we will advocate for that as early and as often as it is possible. I don't have a master strategy that I can tell you right now, but the BRCA is obviously a great step in the right direction that we and many others in the industry all came together to support, as Peter said. But that will not be the end. Like, we will keep advocating to amend 1960 to make sure that this can't happen again.
Thank you. Two more questions. One for Peter, one for Amanda. So Roman Storm is also charged with there's a third charge that he's facing, and this charge doesn't get a lot of airtime, but I know that Peter has thought a lot about it. Specifically, its First Amendment related implications. So what should we keep in mind about the charge? It's the conspiracy to violate sanctions, right? It's the third charge. That's the one that we haven't talked about yet.
Yeah, and that for reasons that escape me that's not a charge that's been brought against the Samourai developers. They just brought that against the Tornado Cash developers, but I'm not sure why they made that prosecution choice, because I think it's a bad charge for either. So the International Emergency Economic Powers Act, IEPA, is the U.S. Primary sanctions statute, and it says that you're not supposed to make transactions with sanctioned persons, and the president can create a list of sanctioned persons and countries. Like the Iranian National Guard is a sanctioned entity, and Iran in general is sanctioned, the government of Iran and the state of Iran. And so you are not supposed to make transactions with those people as Americans. Now, the Tornado Cash charge is effectively that they conspired to evade sanctions, so that they conspired with others to violate sanctioned laws, which means to help Americans and to themselves transact with a sanctioned entity. In this case, North Korea, probably because of the Lazarus Group's usage of the tool, but actually it's very sort of nebulous and diffuse who exactly they think is the party that they're making a sanctioned transaction with. Because the fact of the matter is, if what you've done is publish software and people use that software to make transactions, you didn't make any transactions with sanctioned persons. And so charging you with conspiracy to make transactions with sanctioned persons is inappropriate. Now, the First Amendment issue here that you flagged, and thank you for that, Mike, is important because IEPA itself, the sanction statute, has a carve-out for certain types of transactions that deal primarily in information. They're called the Berman Amendments to the sanctions laws because they were created by a congressman named Berman out of fear that people were abusing sanctions laws to stifle First Amendment protected activity, the publication of speech, ideas, technologies even. And, you know, the case law back then was mostly about like Cuban art dealers who were selling paintings in Florida and how they really shouldn't be charged with sanctions evasion because they're selling art. And, you know, this is actually very relevant too. Like our strongest national security play in general in the world is to be the open society, to be the one like, yeah, if the Ayatollah wants to publish a romance novel in the US, you can distribute his book. It's probably not going to be good if you know, I mean, maybe it is. I don't know. I don't mean to impugn his writing abilities for other reasons, but like the American way isn't to say we're going to shield Americans from bad ideas abroad and use sanctions laws to do that. It's to say, no, Americans can better decide about the things that they think are right for liberty and freedom and justice and the good life by having those information materials available to them. So we won't misuse sanctions laws to block Americans from accessing those things. Tornado Cash is a perfect example of where the Berman Amendment should step in and stop an abusive sanctions charge. Because to the extent the Romans engaged in any transactions, they paid Amazon to host content on a website, and that content is software. And it's software for doing something radically interesting, like making private electronic cash transactions on the internet. It's not money laundering. It's not I'm paying Iran. It's a transaction to facilitate scientific and technological innovation. And so to the extent they can even point to a potentially sanctioned transaction, and I don't think they can because Amazon, the person they're paying to host software, is not a sanctioned person. Even if you treated somehow that transaction as a transaction that ultimately involved North Korea because North Korea used the software that was hosted on the Amazon web server, that is not a sanctionable transaction under the Berman Amendment carve-outs because sanctioning that transaction would be manifestly inappropriate under our First Amendment. Americans want and have a right to see and to pay for and to obtain new ideas for human flourishing, and sanctions shouldn't be abused to stop them from using those tools. So this charge, I think, does get a little less attention because of how way off base the other charges are as well, like the unlicensed money transmission charge, which we spend a lot of time on. But it's equally as dangerous to the free exchange of ideas and encouraging, you know, innovation and protecting our First Amendment rights.
Okay, one last question on the sanctions, and this is separate from the developer prosecutions. Some of you may remember that the Department of Treasury imposed sanctions on the Tornado Cash software in 2022. A federal appeals court ruled late last year that the Treasury had overstepped its authority in doing that. And then in March, the Treasury delisted the software, but there was some nuance there in the way it acted. And it also did not remove sanctions from Tornado Cash developer Roman Semenov. So this last question is for Amanda. Can you explain first the nuances in the way that the Treasury delisted the software and why that matters? And then secondly, the significance of the actions that the department has taken towards Roman Semenov.
Yeah, absolutely. So when OFAC originally listed sanctions related to Tornado Cash, they listed the website, like the Tornado Cash front end, smart contracts related to the protocol, and Roman Semenov, one of the developers. Coin Center, along with others, challenged those sanctions in federal court, and one of those cases got all the way up to the appellate level. It's the Van Loon case. And in that case, the Fifth Circuit said that OFAC's original listing of sanctions on smart contracts were invalid, that they could not actually sanction smart contracts the way that they did that. they're not property, they're not capable of being owned when they're immutable. So that was a win for sure. What you would think would happen was OFAC would say, hey, in accordance with this Fifth Circuit ruling, we're going to delist the sanctions that were ill-conceived of to begin with. Instead, OFAC did a press release that said, in our discretion, we are going to delist the sanctions that we originally put on the Tornado Cash website and the smart contracts. And they didn't say this, but what I think is like the quiet part is they are preserving their ability to relist at some point, but that's like not a problem for today. I just think that there was a word choice there that they crafted. But what they did not do is delist the sanctions on Roman Semenov, the actual developer who was related to the smart contracts. And I think it would have been consistent and made a lot of sense to delist Roman Semenov at the same time that they delisted the smart contracts, because what I think the message is there is, okay, so now people can use this protocol and use these smart contracts, but people can't build them. And I think that keeps us in the same place we were in before, which is chilling innovation, chilling development, and uncertainty as to what conduct actually gets you a sanctions listing.
The one thing I'd add to that, you might be wondering, okay, why didn't they sanction Roman Storm? Because we're talking about Semenov, not Storm. Well, it's because he's an American. He's a U.S. person. And so this actually really highlights something that's very dangerous about our sanctions policy. So I agree with Amanda 100% that the rational thing for OFAC to do after the Fifth Circuit opinion was to just drop all the sanctions. And they almost did that. But the Fifth Circuit technically said they just can't sanction the immutable smart contracts. The Fifth Circuit didn't say you can't sanction anyone having anything to do with Tornado Cash. And so, you know, they weren't under an obligation to not sanction Roman Semenov. But there's something pernicious here in that, should we be using OFAC and the sanctions power, which is probably the most powerful geopolitical force we have short of going to war with a country, to figure out who should be and shouldn't be writing software globally? And we know we can't do that to an American. That's why they didn't even try with Roman Storm, because he's got constitutional rights. You can't sanction Brian Armstrong. You can't sanction Satoshi, assuming Satoshi was an American. I don't know if he was or not, actually. So maybe you could sanction Satoshi. And that's also an abuse of the sanctions tools. We're not going to say, oh, that software in the world causes us some problems with our traditional strategies for stopping money laundering, and so we're going to actually, ban Americans from transacting with the person who authored that software, which is what it means to be sanctioned, right? And there's no due process when you sanction someone. You can't say, I shouldn't be sanctioned for this. I want to challenge it in court. Or actually, before you even sanction me, you have to charge me with something, and then you have to prove that I'm guilty before I get. No, you just immediately end up on a list, and now Americans are banned from transacting with you. You can't get banking relationships. You can't do anything like this. So the fact that the one sanction remains is a foreign developer, not a U.S. person, is kind of ugly. It might be legally kosher in the sense that, yes, without due process, we can sanction foreign persons effectively for almost any reason. But there's a lot of talk right now of global hegemony and U.S. exerting power overseas and all kinds of controversial things. This one, I think, is hyper-controversial. Just because someone writes a book that the American administration doesn't like doesn't mean we should tell Americans they can no longer economically interact with that person. And that's effectively what's going on in the Semenov example.
Yeah, thank you. Amanda, is there anything else that you would add before we let you go, get back to your work?
I would just echo, please support the BRCA staying in clarity as it keeps moving through Congress. Whatever other issues may or may not exist in clarity, that is the most important thing for software developers, in my opinion. And when we do actually come up with a strategy for amending 1960, I hope everybody will support that as well.
Thank you so much, Amanda. I know you have a hard stop at 11:30, so we'll let you go.
Thanks so much.
Paul, do we have more announcements? Okay. Is there anything else you want to add, Peter?
No, this is great. I hope this was helpful and engaging. I know we got into a lot of really weedsy legal issues, and that's just the nature of these prosecutions, is they brought to bear 3 very, very broad and potentially abusable criminal charges: sanctions evasion, money laundering, and unlicensed money transmission, and interpret them in ways that are just very against the rights of the defendants, which is in itself incorrect. We're supposed to interpret ambiguous statutes in favor of criminal defendants because we want people to only be held guilty for conduct that they knew was against the law, not that they should have known that somebody in a crazy way thought might be against the law. And so I appreciate you all listening to us go into depth on all of these different parts of the U.S. criminal code, because I think it really does matter. If people are going to build these good tools in the U.S., they're going to need to know that they're not going to accidentally, through no fault of their own, end up arrested in the middle of the night.
Thank you so much, Peter. I appreciate your time. Thank you, everyone, for coming.
Thanks, Mike.